Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers filming police officers, First Amendment retaliation, and breaches of the peace, and is brought to us by a private submission. Be sure to check out the description below and give them the credit that they deserve. On July 23, 2022, animal rights activist Curtis Vollmer attended a Pioneer Day celebration in Beaver, Utah, along with several other members of the animal rights organization Direct Action Everywhere. The activists hope to engage the community in conversation about an upcoming trial for two animal rights activists who are facing criminal charges for having filmed conditions inside the local Smithfield Foods facility and rescuing two dying piglets while they were there. Originally, the activists hoped to set up a booth, but upon arrival, were told that they needed a permit. So Mr. Vollmer chose to stand on a public sidewalk near the festival instead. After handing out flyers and obtaining signatures for a petition against Smithfield Foods for several hours, Mr. Vollmer was approached by officers from the Beaver County Sheriff's Office.
You have to have a permit.
Permit for a sidewalk?
Let me get my camera on too.
Sure.
Okay. You're not to
This is not a good look.
You're not to be spreading.
This is not a good look.
You're not supposed to be down here.
This is public property.
You're not to be down here doing this. Do you realize that your company caused a problem in our community?
Do you have anything relevant to say to me?
Yes, I do.
Okay.
I've asked you to stop.
Okay, I'm on public property.
You need to stop. Do you realize you're not wanted in this community and you've been asked to leave?
I don't care.
I know you don't care. That's the problem with your group. You just don't care about people or anybody. Do you understand? You've been asked to leave.
All of this for handing out some flyers. This is how much
all of
commotion.
This is because your group has been a direct influence on shutting down Smithfield Foods. You don't realize that's the major employer in our county?
You don't think I know that?
There's a lot of people that have lost their jobs, and you come into this community and pour salt into the wounds of the people that have lost their jobs.
It's not the intent.
You need to well, I don't care what the intent is. What you're doing is causing a disturbance in the community.
I'm not trying to cause a disturbance. I'm just trying to have conversations with people.
You are.
And if people don't want to talk with me, I say thanks for your time and on with your day.
I'm going to stand right here and I'm going to tell people not to talk to you.
Then fine, do that. This is great content for us. Absolutely ridiculous. This is very anti-free speech.
It's
I never
it's
gave
not.
you permission to put me on your film, on your camera.
Okay, are you a public servant?
Yes, I am.
Okay, well then you can be filmed.
No, I cannot. Not a volunteer, public servant.
Okay, you got a badge on.
I'm a volunteer. Now get your camera off.
You need to stop.
Stop what, sir?
Right
Okay,
there.
it's causing a problem in our community.
I'm not trying to cause any problems.
You are.
Listen, sir. When someone's asking you like this, a public servant, he's a volunteer type thing. He's asking you nicely to please don't film him.
Okay.
And we're asking you to stop filming him.
Okay, I won't film him.
We're giving you a lawful order to not do that.
Okay.
If you violate that lawful order, then you're causing a disorderly conduct issue.
We're not filming him anymore. Okay? We're filming you two.
One of the volunteer officers informs Mr. Vollmer that he does not consent to being filmed. And when Mr. Vollmer protests, Deputy Laws states that he was given a lawful order not to film the officer, and he will be committing the crime of disorderly conduct if he disobeys it. Under Section 76-9-102 of the Utah Code, quote, an individual is guilty of disorderly conduct if the individual refuses to comply with the lawful order of a law enforcement officer to move from a public place or an official meeting, or knowingly creates a hazardous or physically offensive condition by any act that serves no legitimate purpose, or intending to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk of public inconvenience, annoyance, or alarm, the person engages in fighting or in violent, tumultuous, or threatening behavior, makes unreasonable noises in a public place or an official meeting, makes unreasonable noises in a private place which can be heard in a public place or an official meeting, or obstructs vehicular or pedestrian traffic in a public place or an official meeting. While the statute does prohibit disobeying a lawful order to move from a public place or official meeting, it does not allow for a disorderly conduct conviction for refusing any other lawful order, including an order to stop filming. Further, even if the disorderly conduct statute did make it illegal to disobey such an order, a court would likely conclude that the order to stop filming a police officer in public was not lawful. In the 2022 case of Irizarry versus Yahia, the 10th Circuit Court of Appeals, which has jurisdiction over Utah, officially recognized the, quote, First Amendment right to film the police performing their duties in public, and held that this right was clearly established law as of 2019. In reaching the conclusion, the court looked to, quote, 3 well-established First Amendment principles that show that filming the police performing their duties in public is protected activity. First, the court noted that, quote, a major purpose of the First Amendment was to protect the free discussion of governmental affairs. Filming the police and other public officials as they perform their official duties acts as a watchdog of government activity and furthers debate on matters of public concern. Additionally, the court reasoned that, quote, without some protection for seeking out the news, freedom of the press could be eviscerated, that there is, quote, an undoubted right to gather news from any source by means within the law, and that video recording is, quote, unambiguously speech creation, not mere conduct. Given the incontrovertible legal precedent, a court would almost certainly determine that Mr. Vollmer was exercising his First Amendment rights by recording the volunteer officer, and the officer's orders that he stop were a clear violation of those rights.
It's only drawing more attention to why we're here, so I appreciate this. Thank you. Do you know about the Smithfield trial happening?
You don't have a permit to approach people, but not your product.
Okay, I don't need a permit to talk to people on a public sidewalk.
You're causing a problem in the community.
I'm not. I'm asking people if they want to have a conversation. If they say no, I let them go.
People
That's
have come to us.
Sure.
They do not want you here.
Okay. That's fine.
Then I'm keeping the peace and I'm asking you to leave.
All we're asking people.
No, I'm asking you to leave.
Okay. Here's an example of what I'm doing. Have you all heard about the Smithfield trial?
Okay.
Okay, they don't want to talk. Okay, that's it. I move on. People don't want to talk, we move on.
Everybody, you don't.
Have y'all heard about the Smithfield trial? The upcoming Smithfield trial?
These are the people that are trying to shut down Smithfield. Okay?
It's not true.
These are the people that are trying to shut down Smithfield.
It's not true.
Mr. Vollmer attempts to speak with multiple members of the public, and each time, Deputy Woolsey tells them not to speak with him because he is trying to, quote, shut down Smithfield. While police officers do have First Amendment rights as citizens of the United States, as government employees, they can face consequences for their speech in ways that private citizens cannot, particularly for speech they make while on duty and in uniform. As the Supreme Court described in the 1983 case of Connick versus Myers, decisions as to when a government employer can take corrective or disciplinary action against an employee for their speech must, quote, seek a balance between the interests of the employee as a citizen in commenting upon matters of public concern and the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. Similarly, the court noted in the 1994 case of Waters versus Churchill that for speech by a government employee to be protected by the First Amendment, it, quote, must be on a matter of public concern, and the employee's interest in expressing herself on this matter must not be outweighed by any injury the speech could cause to the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. Here, while Deputy Woolsey's speech was undoubtedly on a matter of public concern, a court would most likely determine that his interest in expressing his opinion at the time, and in the way that he did, was outweighed by the potential injury to the state's interests, as his actions likely constituted so-called First Amendment retaliation against Mr. Vollmer for his protected speech. In general, the First Amendment prohibits the government from retaliating against an individual for exercising protected expression. As the 10th Circuit noted in the 2000 case of Worrell versus Henry, quote, any form of official retaliation for exercising one's freedom of speech, including prosecution, threatened prosecution, bad faith investigation, and legal harassment, constitutes an infringement of that freedom. The decision also explained that to succeed in a First Amendment retaliation claim, the plaintiff must prove that they were engaged in constitutionally protected activity, that the government's action caused them, quote, to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity, and that the government's action was, quote, substantially motivated as a response to the plaintiff's exercise of constitutionally protected conduct. In this situation, Mr. Vollmer was unquestionably engaged in speech that was protected by the First Amendment, and Deputy Woolsey essentially admitted that he was taking this action because he did not like Mr. Vollmer's past and current speech. As to whether Mr. Vollmer suffered an injury because of Deputy Woolsey's conduct, the 10th Circuit determined in the Irizarry case we discussed earlier in this episode that because, quote, physical and verbal intimidation are cognizable injuries, a YouTube journalist suffered an injury when an officer stood in front of his camera and shined a flashlight into it, now quoting, making it difficult if not impossible to continue recording a potentially critical moment of the police activity. The court also noted that, quote, this injury alone would chill a person of ordinary firmness from continuing to film the traffic stop. Because the 10th Circuit has recognized that interfering with an individual's exercise of protected speech can constitute a sufficient injury for a First Amendment retaliation claim, a court would likely conclude that Mr. Vollmer had a claim against Deputy Woolsey for his attempts to dissuade individuals from talking to him.
More importantly, I'm more important for your safety.
We're not here to talk about that.
No, let me talk.
Go ahead.
I'm more worried about what people here how they feel towards you and your protest. So I'm more or less walking.
We're not protesting.
Let me finish. Don't cut me off, please. I'm more worried about your safety and not some of these citizens being upset with you than anything.
Deputy Laws informs Mr. Vollmer that they are taking these actions out of consideration for his safety and are trying to protect him from the many local citizens they claim are angry with him. However, courts have long recognized that police officers generally cannot censor an individual's controversial speech, even for their own protection. This issue, known as the problem of the Heckler's veto, has been addressed in numerous Supreme Court decisions. And although speech is not protected by the First Amendment when it creates a clear and present danger of riot, disorder, or other immediate threat to public safety, as the court noted in a footnote in the 1966 case of Brown versus Louisiana, quote, participants in an orderly demonstration in a public place are not chargeable with the danger that their critics might react with disorder or violence. In the 1949 case of Terminiello versus Chicago, the Supreme Court overturned a disorderly conduct conviction against a suspended Catholic priest who, in an address that he delivered in a Chicago auditorium, quote, condemned the conduct of the crowd outside, and vigorously, if not viciously, criticized various political and racial groups. Despite the fact that police officers assigned to the meeting to maintain order were not able to prevent several disturbances, and, quote, the crowd outside was angry and turbulent, the court determined that he could not be convicted for disorderly conduct simply because his speech caused, quote, a breach of the peace. In reaching this conclusion, the court explained that, quote, a function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. The court expressed a similar sentiment in the 2011 case of Snyder versus Phelps, where it held that the infamous Westboro Baptist Church could not be sued for protesting soldiers' funerals, noting that although speech can inflict great pain, quote, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course, to protect even hurtful speech on public issues to ensure that we do not stifle public debate. Here, it is clear that most of the citizens of Beaver did not seem to even notice Mr. Vollmer's presence at the celebration, and there was absolutely no evidence that his speech was on the brink of causing any sort of violence or disorder. A court reviewing this situation would therefore almost certainly conclude that the deputies could not censor Mr. Vollmer's speech based on the justification of preventing a breach of the peace.
When you come in on a day that people are trying to enjoy the holiday, and you stir them up, we get calls and complaints about
having conversations, they need to look in the mirror. If people are so triggered and so upset from having a conversation, they need to look in the mirror.
You know what? You need to have a little bit more compassion.
Okay.
Okay? With people.
Okay.
Okay, you don't understand that Smithfield has shut down.
Following the interactions covered in this episode, the deputies cited Mr. Vollmer for disorderly conduct and ordered the activists not to, quote, bring up the issue again at the local horse races and rodeo, which were taking place later that evening. On August 2nd, 2022, Mr. Vollmer and his fellow activists filed a federal lawsuit alleging that the Beaver County deputies, along with the sheriff himself, had violated their First Amendment rights. They also submitted a motion requesting a preliminary injunction that would prevent the sheriff's office from prohibiting speech on public sidewalks or parks, threatening citation or arrest, or citing or arresting the activists for engaging in public outreach, handing out literature, and soliciting signatures. As of the date of this episode, the case and the motion for preliminary injunction are both still pending. I reached out to the Beaver County Sheriff's Office, but I was unable to obtain a comment at this time. Overall, the Beaver County officers get an F for blatantly violating Mr. Vollmer's First Amendment rights, actively hindering his attempts to engage the community in dialogue, and retaliating against him for simply exercising his fundamental right to freedom of speech. It is undeniable that the deputies allowed their personal feelings about the activists, their speech, and Smithfield Foods to interfere with their duties as law enforcement officers. While there was no apparent evidence that anyone in the community was bothered by the activist presence, if the officers truly believed that they were in danger, the Constitution required them to physically protect the activists while also protecting their rights to speech. Instead, the Beaver County officers chose to censor the activist speech and cite Mr. Vollmer for disorderly conduct for doing nothing more than exercising his First Amendment rights. Mr. Vollmer gets an A+ for understanding and defending his constitutional rights, trying to educate the officers on the First Amendment, and maintaining a respectful demeanor throughout the encounter. Although their attempts were ultimately unfruitful, I commend Mr. Vollmer and his fellow activists for trying to engage in meaningful conversation with the officers to explain the protections granted to speakers by the First Amendment, and for immediately taking appropriate legal action against the officers. It seems clear that the officers' actions were incontrovertibly unconstitutional, and it will be interesting to see how this case plays out in the courtroom. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.